Up next, we have disability discrimination. So they changed the laws back in '08. It was always meant to be this way. Even if you were temporarily disabled, it was any discrimination that occurs either because you are disabled or because your employer thinks you are. That's what the law originated out of all the AIDS problems in the '80s, where people were being discriminated against because they thought something about AIDS that wasn't true. Like a mother taking care of a sick son that would be discriminated against because they thought AIDS could spread. And where they get that idea from? A certain
Anthony Fauci, if I'm taking a guess.
Exactly. Anthony Fauci, you said you could get AIDS in your kitchen. That's how long this guy has been a scam artist. But of course, the corrupt corporate whore courts limited the definition to say, no, you have to be permanently disabled. If you're just temporarily disabled, you have no discrimination protection. Your employer can discriminate against you all you want. So Congress went back in and said, no, we meant what we said the first time. Temporary disability also counts. Perceived as disabled also counts. But the Third Circuit was still late to the party. And only this past week did they finally recognize a law that changed in 2008 that their lower courts were misapplying 16 years later. And they were like, oh, you know what? We were always wrong back when we said temporary disability doesn't count. Temporary disability does count. Congress actually changed the law for that back in 2008 and finally fixed it so that there's really robust protection from disability. The other fight on discrimination is going to be the fight on religious discrimination and privacy rights in discovery, which is a case that I have pending before the same Third Circuit Court of Appeals, where 3M, which originally stood for 3MFers, but they hide the FERS part, represented by one of the sleaziest, nastiest law firms in America, rooted in anti-labor movements of the Deep South from the 1920s. It's that kind of nasty history. That's who 3M chose as their lawyers. They discriminated against a bunch of people who had religious objections to taking the COVID-19 vaccine. Those people have now sued, and their reaction is not to reach some resolution with any of them, but instead to threaten them further, to demand that they rat out everybody they know at the company who had any dissident beliefs, to disclose all of their own personal beliefs, political beliefs, religious beliefs, social beliefs, all their affiliations, all their associations. They're demanding that courts turn over all of their social media accounts, their cell phones, actually have their cell phones fully copied and imaged and given to them, their computers copied and imaged and given to them on the grounds, and demanded that they all sign medical waivers to waive any medical privacy and any medical information from any medical provider in their entire life, including in particular disclosing their sexual history. And federal judges, Republican appointed, Democratic appointed, in Pennsylvania, in Georgia, and elsewhere, are ordering people to do this. Ordering because they're interpreting religious discrimination claims that say if you bring a sincere religious belief claim, that you have to prove you're a good Christian. That it doesn't matter if your belief is a Christian belief if you're not a good Christian. It doesn't matter if your belief is a Muslim belief if you're not a good Muslim. It doesn't matter if your belief is Jewish if you're not a good Jew. So we get to now put your whole personal life under scrutiny in ways that even the Star Chamber and the Inquisition would have been embarrassed to do.
I can say, like, if I ever plead religious exemption and they'll say, Viva, well, there's video of you eating lobster and bacon. You're a bad Jew, and therefore no religious exemption.
That's exactly what they're doing. It's that level of insanity. And so now the problem with that is, first of all, the First Amendment limits what federal courts can do. Federal courts are state actors. People tend to forget that. So when they compel discovery, when they sanction someone for not complying with discovery, they are a government actor. That's how a defamation claim has First Amendment implications. Defamation claim is between two private parties. But when the court's involved, it no longer is between two private parties. It's state action. So as soon as the courts start ordering discovery, as soon as the courts start sanctioning for not providing discovery, they are violating the First Amendment to the U.S. Constitution if they're doing so in a religiously discriminatory manner. They're also violating the First, Fourth, and Fifth Amendment to the U.S. Constitution if they're doing so in a way that invades your privacy, that demands you disclose your private political affiliations or expression. demand you disclose your religious affiliations or expression, demand you disclose your intimate activities and intimate relationships. And so the First, Fourth, and Fifth Amendment limit the scope of discovery a court can ever order or a sanction it can ever issue. In this case, the judge ordered insane discovery. This is that judge who's a chancellor of a university in England. At the same time, she's a federal judge.
Off the bench.
Another judge, another foreigner who grew up the daughter of a Brit on the American bench. Barack Obama loved putting foreigners on our federal bench. And in my view, we did a revolution to kick the Brits out. I don't want Brits coming back to tell us what our Constitution says and doesn't say. So that's who this judge is. So this judge first orders an insane amount of invasive discovery. We produce an insane amount of discovery, but they don't like that it's not invasive enough for 3M. So 3M seeks to dismiss the case because they didn't get the full level of nudity they wanted. And the federal judge, without even allowing a hearing, dismisses the entire case on those grounds. So we've appealed it to the Third Circuit Court of Appeals for abuse of power because people forget judicial dismissals are also state action that triggers First Amendment, Fifth Amendment, Seventh Amendment issues, right? When you under the First Amendment, you have a right to petition the government for redress of grievances. That includes your right to judicial remedy and relief and a judicial hearing and your day in court. She was denied that, my plaintiff, in this case. Under the Fifth Amendment, you have a right to due process of law. You cannot lose property or liberty or life without due process of law. That is both procedural and substantive guarantees. Here, she wasn't even given an evidentiary hearing. So she was deprived of a certain liberty without due process of law, and she was deprived of it without even an evidentiary hearing. So it was a violation of both substantive and procedural due process. And last but not least, this is a monetary relief case, monetary remedy case. What does that mean? Triggers the right to trial by jury. And so if you have the right to trial by jury, this was not trial by jury. This was trial by judge. And consequently, without even a real meaningful trial by the rules of evidence. And so consequently, that was a violation of the Seventh Amendment to the U.S. Constitution. Courts are so used to abusing their dismissal power that they forgot the constitutional constraint on that dismissal power, just like there's constitutional constraint on their discovery power. And so that's why we're going to be, and it's impactful for everybody, because what's supposed to happen in religious discrimination cases is the belief objectively religious. Like, let's say somebody thinks their tattoos matter to them as much as any religious belief does to anyone else. However, if it's not objectively a religious belief or equal to a religious belief, then it doesn't count for discrimination cases, regardless of the person's subjective perception. It's supposed to be objectively. Is the belief a sincere religious belief? Not, is the person a sincere religious practitioner? It was never an invitation for courts to conduct heresy trials as the new inquisitors of America. And yet federal judges who hate people who bring religious discrimination claims, especially concerning the COVID-19 vaccine, are reinterpreting their power to give them power that even the Inquisition did not claim. And that's why we're going to be challenging this in every case going forward. And this case has great consequence beyond just this case.
I say phenomenal, but not phenomenal, but Godspeed.